Resume today, Wednesday, the 26th day of October 2022, before His Lordship, Honorable Justice Sanusi Ado, presiding. Suit number NICN CA 55-2018 between 1. Orok Edem View. 2. Joseph Okon Mbopa. 3. Amos Etienne Ofiong. 4. Pius E. Efiu. 5. Eta Ekong Eta. 6. Samuel Usemo. 7. Sylvester Efifio Usa. And 30 others. And Adams Petroleum Development Limited. My Lord, the first, second, fifth, sixth claimants are in court. Others are absent. Defendant is absent.
Appearance.
With all due respect to your lordship,
Yes.
all chats works, President. But today, and yet, of what we said, OKPONG. For the claimants.
You say Aniebe.
Aniebe of bomb. OKPO. Aniebe lodge. I want the lordship to be able to spell our names.
Yes.
Yes, for the claimants.
Yes.
With profound respect, my lord.
Yes.
My name is Stanley. You.
Stanley,
Weke Eze. Weke Eze.
In Weke or Weke?
Weke, NWEKE hyphen EZE.
Okay.
My appearance is for the defendants, my lord.
Yes, this matter is for judgment. The judgment is ready. Yes, this is the judgment of the court. By the general form of complaint dated and filed on the 18th day of November 2018, the claimants praise the court for the following reliefs. They are: 1, a declaration that in consonance with the judgment of the Honorable Court in suit number NICN/C/08/2016 versus Adax Petroleum Development Company Limited, the defendant's action of merely stopping the payment of salaries of the claimant without any termination notice or pay-offs is unacceptable in law. And order 2, an order directing the defendant to calculate and pay to each of the claimants all their outstanding salaries and entitlements up to the date of judgment, up to the date judgment is delivered in this suit. 3, an award of the sum of 30 million naira as general damage to each of the claimants and pay as payoffs. The defendant filed his statement of defense on the 8th of May 2019, wherein it denied the claims of the claimant. Joseph Okon Mbukpe, the second claimant, testified in proof of the claimant's case as CW1. After identifying his witness statement of oath, he tendered some document in evidence. Under cross-examination, CW1 testified that each of the claimant has contract of employment with the defendant. Each of the claimant have amount to be paid to him under the contract. The claimant receives the same amount as salary. The bank statement shows that same amount was paid to each of the claimants as salary. There is no entry of sum of 240,000 naira in Exhibit C10. CW1 agreed with the counsel for the defendant that the amount credited are not same. CW1 is representing all the claimants. The other claimants have statement of accounts in court. All the statement of accounts of the claimants are with their lawyer. The bank statement of accounts tendered are what the claimants have before the court. CW1 is not in a position to say whether other claimants have received their retirement benefit or not. CW1 is in court to testify for himself and others. In the witness statement on oath deposed by CW1, he mentioned deposed by CW1. In the witness statement on oath adopted, CW1 mentions Seawolf and Transocean. He is not aware if they are independent. He is aware they are owned by Adax Petroleum. He cannot speak of Seawolf and Transocean. All he knows is that Adax posted them from one rig to another. The rigs were owned by Adax. He does not know any other business of the dependent in Cross River State. He agrees that the owner of the rig determined workers to work at the rig. Adax employed the claimants as host communities and they applied for it. The application is not before the court. The claimants attended interview and they were trained, but they were not given letters of employment. Their names were pasted. They undergo training. They were not given ID card. The process of employment took 1 week and training took 2 weeks. CW1 is not aware if Adax has contract with NNPC. Mr. Orok Edem Duke, the first claimant, testified as CW2. He identified his witness statement and adopted same as his evidence in this case. He also gave evidence under cross-examination. Under cross-examination, I will skip reading that one. Then the claimant's case, I have captured the claimant's case as encapsulated in the pleading and evidence before the court. I will skip reading that one. The case of the defendant also, I have captured the case of the defendant as it is encapsulated in their defense and also the evidence before the court. I have also captured the submissions of the defendant wherein they formulated 3 issues for determination. The argument has been captured in the body of the judgment, so counsel will read when they get the hard copy. I have also captured the submissions of the claimant. I will skip reading the submissions and go straight to the decision of the court as to save time. I have carefully perused the processes filed by the evidence laid, as well as the written oral submissions of counsel before the court. From the facts revealed by the pleadings and evidence before the court, the main issue the court is to resolve centers whether or not the claimants are entitled to any of the reliefs being sought before the court. However, before delving into the determination of the issue calling for resolution, I shall endeavor to deal with 2 preliminary issues that were raised by the parties. The first preliminary issue is whether the claimants are employees of the dependent. The dependent has maintained in their pleading before the court that the claimants were not employees of the defendant. According to the defendant, the claimants were employees of Seawolf Transocean Support Services Limited, and that claimants' employment with the Seawolf and Transocean elapsed on 28th day of February 2011, and they have all been paid their terminal benefit. The defendant also is of the view that there is no need for termination of claimant's employment, as the said employment has ended on the 28th day of February 2011. For the claimant, they insisted that they were employees of the dependent. they were employed after they attended interview. They also undergo training for 2 weeks. Thereafter, they were deployed to various platforms to work. Some were posted to work with Sea-Wolf oil rig called Onome. Others were deployed to maintenance on the ground. The claimants have in proof of their employment asserted that the defendant did not issue letters of employment to them. And upon their employment and deployment by the defendants, they were paid salaries by the defendant from 2010 when they were engaged till 2015 when the defendant suddenly stopped paying them their salary without any notice or pay-ups. The law is right. He who asserts has the onus of proof to prove his assertion. The claimants who have asserted that they were employees of the defendant have the onerous task of proving this before the court. The claimant have in support of their claim about that they were employed by the defendant. They relied also on the provisions of Section 91 of the Labor Act on definition of worker and the Supreme Court decision in the case of Shena Securities Limited versus Afro Park Nigeria Limited. The defendant on it had maintained and insisted that the payment of salary is not enough to establish employment relationship. They relied on the case of FCDA versus Odukon. It is through employment relationship that reciprocal rights and obligations are created between employer and employee. The employment relationship has been and continue to be the gateways through which employee access rights and benefit associated with employment. Where there is no contract of employment, there can be no talk of rights and obligation in relation to the parties in dispute. An employment relationship is created under any contract of hire, expressly or impliedly, oral or in writing, going by the provision of Section 91 of the Labor Act, which defines employer as any person who has entered into contract of employment to employ any other person as a worker, either for himself or for services of any other person, and it includes the agent, manager, or factor of that mentioned person and the personal representative of a disease mentioned person and the personal representative of this employee. The same section defines worker as any person who entered into work under a contract with an employer, whether the contract is for manual labor or clerical work, is expressed or implied or oral or in writing, and whether it is contract of service or contract for to personally execute a work or labor, It, however, does not include A, any person employed otherwise than for the purpose of employer's business, or B, person exercising administrative, executive, technical, or professional function as public officers or otherwise, or C, members of employees' family, or D, representative agent of uncommercial travelers, insofar as their work is carried on outside the permanent workplace of the employee's establishment. E, any person to whom articles or materials are given out to be made up, cleaned, washed, altered, ornament, finished, repaired, or adapted for sale in his own home or on other premises not under the control or management of the person who gave out the article or material. And E, any person employed in vessel or aircraft to which the law regulates merchant shipping or civil aviation. The above definition of worker in the Labor Act excludes certain categories of employees. Thus, agent, members of employees' family, persons employed otherwise than for the purpose of business, persons exercising administrative, executive, technical, or professional function as public officers, etc. are not workers. Yet these categories of workers are regarded as employees under some other legislation. This means under the Labor Act, those listed as excluded from the definition of worker will not be covered by the provisions of the Act, where other laws contemplate them in their application by their definition. Such laws will regulate their employment relationship. For instance, under Employee Compensation Act, several of the category of workers excluded in the Labor Act are included in Employee Compensation Act. The difficulty in arriving at proper status of an employee has been prevalent over the years, leading to the court evolving certain criteria for identifying an employee. The Supreme Court has, in the case of Shena Securities versus Apropac Limited, gave a further insight on the current legal position on how to ascertain the requisite legal status of an employee as against independent contractor. The Supreme Court stated where there is a dispute as to what kind of contract of employment parties entered into, there are factors which will usually guide a court of law to arrive at the right conclusion. One of such factors is if payments are made by way of wages or salaries. This is indicative that the contract is one of service. The court also stated that it is not pattern to the existence of a contract of service stroke employment that the work is not carried out on its employees' premises. Due to the dynamic nature of employment relationship, which was as a result of globalization, there are emerging new forms of employment relationship. This court has, in the case of Pengasam versus Mobile Nigeria Unlimited, 2013-32 NNLR 39-243, recognized the emergence of new forms of employment. The court, in determining existence of employment relationship, will not be bogged by the name the parties called or describe their relationship. It is the fact of each case that will determine or otherwise of employment relationship. Let me now examine the facts presented by the claimants to establish their employment status. According to the claimant, they were employed by the defendant and deployed to work at Seaworld Oil Ring and in maintenance on the ground. The employment of the claimant was after they had attended interview and undergo training for 2 weeks. Some of the claimants were deployed to work at Onome Oil Rig owned by Seaworld and some others to maintenance on the ground. However, when Onome Rig broke down and upon arrival of DXP Rig owned by Transocean Support Services, they were deployed to work with the Transocean Support Services Limited. In support of the assertions, the claimants have tendered some bank statement of accounts which were admitted in evidence as Exhibit C4, C5, C6, C7, C8, and C9 and C10 to show that the defendant was paying the monthly salaries of the claimants from year 2010 when they were employed till 2015 when the defendant suddenly stopped paying them their salaries without any notice or payoff. A contract of employment means any agreement, whether oral or written, express or implied, where one person agrees to employ another as a worker and that other person agreed to serve as employer to serve the employer as a worker. See the case of Yere versus BFFF Limited. See also Shena Securities versus Apropac Sufra. See also Idigbe versus University of Ilorin. See also Ibama versus SPDC. See Imolome versus Wayek, and host of other cases cited therein. However, there is a world of difference between a contract of employment or appointment itself and the conditions of service issued by an employer to regulate employment generally. A contract of employment or appointment between the employer and employee is a legal document governing the relationship between employer and individual employee on the terms and conditions specifically and freely agreed by them. The conditions of service issued by employer in respect of all categories of employees in its employment generally relate to and regulate the performance of the obligation, duties, and rights of the parties under their individual categories of contract between them and the employer. Conditions of service are therefore issued on the basis of terms of conditions of the contract between the employer and employee. Conditions of service are designed primarily to support the contractual rights and obligations created and agreed to by the parties themselves. See Baba versus Incat. See also Incat versus Baba versus Incat. It is to be noted there is always difficulty, as noted earlier, there is also difficulty in ascertaining employment status when there is no written agreement to that effect. As pointed out earlier in this judgment, the court in Nigeria have devised means of ascertaining contract of service. In Nigerian Airways Limited versus Gojumo, the Court of Appeal has held that where one party employs another, appoints him to various positions in his establishment, pay his salaries and allowances, these are sufficient facts from which a contract of employment can be inferred. Applying this principle as enunciated by the Court of Appeal and the provisions of Section 91 of the Labor Act, as well as the decision in Sena Securities versus Apropac, to the facts of this case as enumerated above, I have no choice than to come to the conclusion that the claimants have, by the evidence adduced in the course of trial, succeeded in proving that they are employees of the dependent. The reason being that the dependent negotiated the contract of employment, posted the claimants to deploy the claimants to the rings where they serve sea wolves and transocean services at the premises of the dependent. And it was the dependent that pays the salaries of the claimant from 2010 till 2015 when the dependent salaries were stopped. With the discharge of the burden of proof imposed on the claimants by Section 131 of the Evidence Act, the burden has now shifted to the dependent to prove the defense put forward before the court. The defense of the defendant is as encapsulated in paragraphs 2.3, 2.4, and 2.5 of the Statement of Defense. According to the defendant, the claimants are not employees of the dependent. The claimants were employed by Seawolf Oil Ring Transocean Support Services Limited. The dependent further stated that the employment of the claimant with Seawolf Transocean Support Services had elapsed on 28th day of February 2011. The dependent has, however, failed to adduce any concrete evidence in proof of the claim that the claimants were employees of Seawolf Transocean Support Services. The reason being that the dependent has not tendered any letter of employment of the claimants, which it claimed were issued by OML, a subsidiary of Seawolf. The failure of the dependent to tender the said letter is detrimental to the defense put forward by the dependent. And it means that if that letter has been tendered, it will be detrimental to the case of the dependent. The dependent has also failed to call any of the officers of Seawolf or OML to testify on the alleged employment of the claimant. The dependent, in order to support its claim that it is not the employer of the claimant, as it only serves as a facilitator, that is to say, a go-between the claimant and Seawolf, the dependent tendered Exhibit D1, D2, D3, and D4 in evidence. However, a careful perusal of this exhibit will show that these documents are not capable of establishing the assertions of the dependent. Exhibit D3 claimed to be minutes of meeting between the dependent and Seawolf, where discussion centers on MOU with host communities for Seawolf to employ 46 youths from where Seawolf operation will be carried out. This exhibit, apart from being a photocopy, the purported MOU, which is the pivot of the discussion, was never tendered before the court for the court to be able to ascertain its authenticity and whether there was actually those things that said to have been agreed in the MOU. Therefore, the Exhibit D3, being an incomplete document due to non-tendering of MOU, lacks evidential value to establish any assertion by the defendant. For Exhibit D1 and D2, they also lack evidential value to prove that what it seeks to establish. The reason being that in Exhibit D1, the meeting was said to have commenced at 1610 hours and ended at 1820 hours, while for Exhibit D, the meeting was said to have commenced at 1700 hours and ended at 2052 hours. If it is true that a meeting actually took place from 1610 hours to 1820 hours as per Exhibit D1, then how comes by Exhibit D2 the meeting commenced at 1700 hours? This means that at 1700 hours, when the meeting in Exhibit D2 was said to have commenced, the meeting in Exhibit D1 was still in progress. This clearly shows that it is not possible for the defendant who has been represented in the purported 2 meetings by the same set of people to be in the 2 meetings at different time at 1700 hours. With this discrepancy regarding the timing of the meeting, I quite agree with the submissions of the claimant that the minutes of the meeting were the purported meeting were contrived by the defendant, as it is doubtful if the defendant can be in 2 meetings with different groups at the same time to be having separate meetings when particularly it is represented by the same set of people. This is incredible. With this finding, I attach no weight to Exhibit D1 and D2, and the said exhibit are hereby discountenanced for the purpose of this judgment. The defendant has also tendered Exhibit D4 in evidence. This exhibit is not relevant to this case. The reason being that the purported employment issue in Exhibit D4 is in respect of communities in Bayelsa State and not those in Cross River State and Akwa Ibom State, which is the issue before the court. Therefore, Exhibit D4 has no relevance to this case. I attach no weight to it, and same is hereby discountenanced. It is to be noted that there is a clear distinction between admissibility of document and weight to be attached to that document. A document may in law be admissible, but may at the end of the day have no evidential value, which means that the document is worthless as it is incapable of proving any assertion before the court, and the court will have no business giving it serious consideration. Therefore, Exhibit D1, D2, D3, D4, and D4 have no evidential value. This finding translates to coming to the conclusion that the defendant never acted as facilitator or a go-between the claimants and COP in the employment process that culminated in the employment of the claimant. What this finding leads to is that the only evidence available is the evidence of the claimants that they were duly employed by the defendant and deployed to work at various rigs or OML 123 belonging to the defendant. The defendant has also stated that the payment of salaries to the claimant was done on behalf of COP/Transocean Support Services Limited on the agreement that the defendant will be refunded of the amount paid the claimant. However, the defendant had not adduced any iota of evidence in proof of this assertion. The defendant had not tendered evidence of the refund made to it of the payment it made to the claimant on behalf of Transocean Support Services Limited. Indeed, the claim of the defendant that broke the camel's back was the assertion that the employment of the claimant elapsed on 20th day of February 2018, and they have all been paid their entitlement. However, there is no scintilla of evidence adduced by the defendant in proof of the purported lapse of employment of the claimant on 28th of February 2018. And there is also no evidence of payment of the purported entitlement of the claimant as at 28th day of February 2011. What is before the court is even continued payment of salaries to the claimant by the defendant till 2015. This shows that the claimant contract of employment did not elapse on 28th day of February 2018. Even if it had lapsed, the continued payment of salaries despite lapse of the contract clearly shows that the contract has been renewed by the defendant. The continued payment of salaries was confirmed by DW1 under cross-examination when he admitted after seeing Exhibit C4, C5, C6, C7, C8, C9, and 10 that the salaries of the defendant continued to pay the claimants their salaries up to 2015. The defendant has insisted, while relying on Odubnom versus FCDA, that payment of salary is not enough to prove employment, while the claimants relied on Shena Security Limited versus Apropac Limited. It is to be noted that the case relied by the defendant was decided by the Court of Appeal in 1996, while the case relied by the claimants was decided by the Supreme Court in 2008, and it was made it. And it was categorically made clear by the Supreme Court that payment of salaries can establish employment relationship. This means that the decision will prevail over that Court of Appeal. It is patently clear from the above analysis of the facts and evidence adduced by the parties, the case law and statutory provisions relied upon by the claimants. This court can safely infer that the dependent did employ the claimants and deployed them to serve at various platforms as claimed by the claimants. This is because the dependent had willfully failed to prove that the claimants were employed by Ocean Support Services Limited or any other person other than the dependent. This position is also supported by the decision of the in the case of Mobil Oil Producing Nigeria Unlimited versus Ocon Johnson, reported in 2018, 14 kilo report, part 1639, page 329. The second preliminary issues that need to be thrashed out before considering the main issue for resolution is whether the claimants that have not testified before the court are deemed to have abandoned their case. The dependent is of the view that apart from first and second claimants who testified in proof of their cases, the other claimants having not appeared before the court to testify in proof of their claims, they are deemed to have abandoned their claims. Let me say that there is no law prohibiting a party from calling a particular witness or witnesses of his own choice in aid of his or her case. In the instant case, the assertion by the counsel for the defendant that a party, if apart from CW1 and CW2 who appear to testify, other parties' claimants are deemed to have abandoned their pleading due to lack of their physical presence to give evidence in proof of their case cannot be correct. The two witnesses that have testified have stated that they have consent of the other claimants on record to give evidence on their behalf, on behalf of all the claimants. This clearly goes to show that the two witnesses have the evidence of the two witnesses is in respect of all the claimants that are before the court. The claims, the claimants are free to call witnesses of their choice, as there is no law that says all claimants must appear in court personally to testify in proof of their claim. All that is needed is adducing qualitative evidence. See Bello versus Kasim, reported in 1969, 1 SCNLR 440. See also Ali versus Ale Shiloye, reported in 2006 Nigerian Kilo Report, part 660, page 177. See also Rematon Services Limited versus Name Insurance PLC, reported in 2020, 14 Nigerian Kilo Report, part 1744, page 281. Coming to the main issue for determination, i.e. whether the claimants have established entitlement to any of the relief sought, the law is right that a claim is circumscribed by the relief sought, and the duty of claimant, therefore, is to plead only such facts and materials as are necessary to sustain the reliefs and adduce evidence to prove them. See the case of Gabriel Atibi versus Camel Metal Nigeria Limited, reported in 2010 LPLR 591SC. Relief 1 is for declarations that, in consonance with the judgment of this honorable court in suit number NICS/CS/OH/26 AOFM02 versus Adex Petroleum Company Limited, the defendant's action of merely stopping the payment of salaries of the claimants without any termination notice or payoff is unacceptable in law. From the three reliefs being sought, it is clear to me that the claimant's action is centers on the arrears of salaries and other entitlement as a result of stoppage of their salaries by the dependent. In an attempt to prove this relief, one, the claimants have averred that the dependent employed them and deployed them to work at various platforms. From the date of their employment in 2010, the dependent pays their salaries through their bank's accounts with the Sterling Bank, with the third Sterling Stock First Bank till 2015, when the dependents stopped payment of their salaries without notice or payoff. Some bank statement of accounts of some of the claimants were tendered and admitted in evidence and marked as Exhibit C4 to C10. The dependent has argued that the claimants have failed to prove entitlement to any of the reliefs being sought because they failed to tender their contract of service as evidence by letter of appointment and staff handbook, which contain the terms and conditions of service. The law is well settled that the claimant must first plead and prove their conditions of service and how the dependent breach the said terms and conditions of service. Thus, the condition of service is accordingly sine qua non in any claim for wrongful dismissal or termination, for only the conditions of service can be used to determine wrongfulness or otherwise of dismissal or termination. Therefore, the duty of the claimants complaining of wrongful or unlawful termination is to present their conditions of service and state how the conditions of service were flouted by the dependent in dispensing with the claimant's employment. The claimants have informed this court that the dependent did not give them letters of employment when they were engaged. All that happened is that the claimants were interviewed, trained for 2 weeks. Thereafter, they were deployed to work at various platforms and sent some of them to maintenance on the ground. The dependent has made heavy weather on the claimant's failure to tender in evidence their letters of employment and the terms and conditions of service. I do not see how dependent will expect the claimants to tender letters of employment in evidence when they have categorically stated that the dependent has not given them such letters. In the face of the denial of being given the letters of employment, the onus has shifted to the dependent to prove service of the said letters of the claimant on the claimant. The dependent having not adduced any evidence to establish that letters of employment were served on the claimant cannot insist on those letters which the claimant denied being received to be produced by them. Let me say here that letters of employment and staff handbook which contain terms and conditions of service contain express terms and conditions of service. However, the law has recognized that in some cases, there may be absence of express terms of contract of employment, evidence in writing. In such circumstances, the law recognizes implied terms to govern contract of service. In the case at hand, as in the like in the case of Nigerian Airways Supra, where the court in fact inferred existence of contract of service. In such where the court inferred existence of contract of service. In cases of such nature, where the conditions of service or later employment is not available, the law recognizes implied terms to govern contract of service. In the case at hand, it is the implied terms of employment as encapsulated in the principles of common law and statutes that govern the employment relationship between the claimants and the dependent. There is no dispute that the employer has the right to terminate or dismiss its employee. This right inures even where there is no written contract of service or employment later. The exercise of the right to terminate or dismiss is exercisable subject to the requirement of giving requisite notice and opportunity of being heard. See the case of Simon and Anasebe versus Bank of the North Limited, where it was held that the court held that the fact that there is no specific provisions as to termination or summary dismissal in the terms of contract will not prevent the employer from exercising his right to terminate or dismiss. See also ZD versus River State Civil Service Commission, which held that it is now firmly settled that in statutory employment, just as in private employment, an employer can summarily dismiss his servant in all cases of gross misconduct, provided, of course, the employer is given the opportunity of fair hearing. In Relief 1, the claimants are relying on suit number NICN/A/008/2016 to press for the declaratory order. In any event, the court is only bound to determine case brought before it based on the facts and evidence presented by the parties in dispute. The court can only rely on its previous decisions as a guide. It has to be remembered that what the earlier decision of this court established is only principle, not a rule. Rule operate in an all or nothing this dimension. Principles do not. Principles merely incline decisions one way or the other. They form a precipitatum or a starting point. Ultimately, the decision of the court will largely depend on peculiar facts and circumstances of the case in hand. The law is tried that a party seeking declaratory relief declaration must succeed based on strength of his case, backed by cogent, concrete, and credible evidence, and not on admission or weakness of the defense. See the case of Dumes Nigeria Limited versus Wokoba and 3 others. See also Akinola versus Olowu. See also Bello versus Iweka. Therefore, claimants cannot succeed on evidence of the defendant. They can only succeed on their own evidence. As pointed out earlier in this judgment, the parties to the contract of employment have right to terminate in compliance with the terms of engagement. Where there are no written terms of contract of service, the parties can dispense the services by implied terms. An implied term requires that reasonable notice of termination be given or payment in lieu of notice. In Honica Sawmill Nigeria Limited versus Hoff, the court held that dismissal of an employee or termination of his employment may be expressed in clear terms or capable of being inferred from the conduct of the parties. See also Abu Koba versus Africa Timber and Flywood Limited. See also Daniel versus Shell BP Petroleum Development Company Nigeria Limited. See also Calabar Cement Company versus Daniel. Thus, the court will read into any such contract a provision that the contract is determinable with reasonable notice. The implied terms may also be provided for by the statute. See also Section 11 of the Labor Act. There is no dispute. The claimants were not given notice. Their salaries were abruptly stopped. Since termination can take place in any form, either by writing, oral, or by conduct, I came to the conclusion that the stoppage of the claimant's salaries amount to wrongful termination of their employment. I find and so on. Relief 2 is for an order directing the defendant to calculate and pay to each of the claimants all their outstanding salaries and entitlement up to the date of judgment is delivered in this suit. Relief 2, which seeks for payment of all outstanding salaries and entitlement up to date of judgment is a claim for special damages, which by the decision in the case of UTC Nigeria Limited PLC versus Samuel Peters, reported in 2022, LPELR 57282 SC, and the case of Luke versus Onyiro versus Benedict O. Onyiro, reported in 2019, LPELR 49096 SC, and 7-Up Bottling Company PLC versus Augustus, also NNPC versus Clifford Nigeria Limited, and Okapo and others versus Obio and another, must not only be specifically pleaded, particularized, but must be strictly proved by credible evidence. The claim for special damages in labor relationship must meet the twin requirements of proof as to entitlement and how the quantum of the sum claim was arrived at. See the case of Suraju Rufai versus Bureau of Public Enterprises. And by the decision in Mohammed Dungus and others versus ENL Consortium Limited, the court there is little or no attempt by the claimants to meet these two requirements. To meet these two requirements in both their pleading and deposition. Furthermore, the oral testimony of the claimants witnesses is not convincing proof for a claim for special damages, except if corroborated by some other credible evidence, and there is no such documentary evidence. In fact, Mr. Joseph Akinola and others, Lafarge versus Lafarge Wafco Nigeria Limited, specifically caution against reliance on oral evidence in proof of entitlement. The claimants by relief 2 are claiming salaries arrears from the date of stoppage of their salary till judgment is delivered. The claimant have not stated the quantum of their claim as salaries for the period of the claim. There is also no particularization of the claim. The claimants having failed to satisfy the requirement of specially pleading of the claim, particularization and strict proof of the claim, they are not entitled to grant of the claim as per relief 2. See the case of 7-Up Bottling Company PLC versus Augusto and NNPC Clifford Nigeria Limited Sufra. The claimants have not proved or established that since the stoppage of their salaries, they have been working for the defendant. The failure to establish that the claimants have been working for the defendant since the stoppage of their salaries means that they are not entitled to payment for the period they did not render services to the defendant. For the claimants to succeed on payment of salary, they are duly bound to show that they have worked for the period of claim. The mere fact that a party is employee of an employer alone cannot entitle that employee to salary. There must be evidence that the employee worked for the employee worked for the employer to earn the salary. In Honica Sawmill Limited Sufra, the Court of Appeal held that as between an employer and employer and an employee, the onus is on the employee to prove that the employer employed him on a stipulated salary and that he worked for the employer during the relevant period. It is for the employer to prove not only that he paid the employee his salaries for work done by the employee in the relevant period, but also how much the salary that he paid to the employee. The claimants have not shown that they have worked for the defendant for the period when their salary was stopped up to the date of this judgment. Therefore, they have failed to prove entitlement to relief 2. Same is hereby refused. Furthermore, the way and manner relief 2 was couched shows that the relief is vague and uncertain. The wording of these reliefs clearly demonstrated that the claimants are not certain or sure of what they are claiming before the court. This kind of relief is not grantable in law, as the Supreme Court has in the case of University of Jos versus Dr. MC Ike Goha, reported in 2013 Nigerian Law Report, part 1360, page 478, has stated that a claim for salary allowances and the like without particularization as to how the sum was earned and arrived at makes such a claim based. The claimant's failure to specify the exact amount they are claiming as salary is fatal to their claim. By relief 3, the claimants are seeking for an award of the sum of 30 million naira to each one of them as general damages, each one of them as payoff. By this relief, the claimants are seeking for payment of damages. The question that comes to mind is, what is the remedy for wrongful termination? The answer is it is damages, and the damages cannot be at large. See the case of Emego Benson Ikemba versus Private Company Limited, reported in 2021 LPLR 56145 CA, where the court held that where termination of employment is deemed wrongful, the only remedy open to the aggrieved employee is payment of damages, and such damages is not at large. The measure of such damages is salary for the length of the time for the notice of termination, which ought to have been given in accordance with the terms of the contract of employment or agreement between the parties and other entitlement due to him. Also in Keystone Bank Limited versus Mr. Joseph Onario Tako Clark, reported in 2020 LPALR 49732, the court held that where employment is wrongfully terminated, the employee is entitled to salary and entitlements over the period of notice. In this case, 1 month notice. It is certain that once an employee takes steps to terminate a contract wrongfully, the contract still remains terminated. The court cannot find otherwise. It is contradictory for the respondent to assert he is still in the employment of the appellant and still claim the reliefs he did before the trial court. End of quote. The decision in the case of Keystone Bank Sufra maintained that once an employer evinces the intention to terminate an employment and takes steps in that direction, the termination becomes effective. Though wrongful, the word of Keystone The Keystone Bank insisted that it is right that wrongful termination remains a termination, even from the date the wrongful step was taken. In view of the foregoing authorities, the claimants cannot even claim relief too, as the alleged stoppage of salary that terminated the employment of the claimants took effect in August 2015, when the defendant evinces intention to terminate their employment by stoppage of payment of their salaries. The act of stoppage of salary, even if wrongful, has made the termination effective from the date of the stoppage, and so the measure of damages for wrongful termination, according to the decision in the case of Emego Vincent Ikemba Sufra, is the salary for the length of times for which the notice of termination ought to have been given in accordance with the terms of the contract. Incidentally, therefore, the absence of written terms and conditions of service, the court is left with no other options than to resort to implied terms of the contract common law, representing the termination of employment, which requires giving reasonable notice or payment of salary in lieu of notice for the period of notice. See Abu Koba versus Africa Timber Plywood Limited, see Daniel versus Shell Petroleum, see also Calabar Cement Limited versus Daniel. Also, by Section 11, subsection 1 and 2D of the Labor Act, the notice period to be given to the claimant in this case is 1 month salary where the contract of employment has continued for 5 years. From the evidence before the court, the claimants were employed in 2010 and they were terminated in 2015 when their salaries were stopped. This means they served for 5 years. So the measure of damages is 1 month salary in lieu of notice, which certainly is not 30 million naira that the claimants are claiming before the court. As per Relief 3, It is to be noted only first, second, fourth, fifth, 12th, 13th, and 23rd defendants have tendered their bank statement of accounts, which were admitted as Exhibit C4, C5, C6, C7, C8, and C9, and C10. Therefore, it is only these 7 months that are entitled to be paid 1 month salary in lieu of notice of termination. The other claimants have failed to convince that they are on the payroll of the dependent, as there is no evidence to that effect. To my mind, the payoff being claimed by the claimant is terminal benefit. For the claimant to be entitled to this kind of claim, they must establish entitlement to it. The claimants did not put forward before the court the instrument that entitles them to pay off. This court has consistently held that in labor relations, an employee can only claim if he/she shows an entitlement, and an entitlement is shown by reference to law that gives it the collective agreement from which the entitlement was agreed on between the contracting parties, or the conditions of service governing the relationships of the employee and his employer. In the case at hand, there is none of this. There is none of this issue before the court. Therefore, the claimants have failed to prove entitlement to pay off. See the case of Mr. Mohamed Dungus and others versus Inel Consortium Limited. Relief 3 cannot thus be granted since an entitlement to it has not been shown to this court by the claimant. Entitlement to pay off has not been established by the claimant. On general damages, let me state that in employee relation damages, recovery is the amount the claimant will be entitled to for period of notice of termination, and not general damages as in the case of other contracts or torts. On the whole, the claimants have succeeded. In fact, for avoidance of doubt, the order of the court is as follows. A, the termination of claimants' employment by stopping their salaries is wrongful. B, the first, second, fourth, fifth, 12th, and 13th, and 23rd claimants are entitled to be paid the sum of 240 to each one of them as as 1 month salaries in lieu of notice. The dependent is hereby ordered to pay the sum of 240,000 to each of the first, second, fourth, fifth, 12th, 13th, and 23rd claimants. Their 1 month salary in lieu of notice of termination. D, the dependent is hereby ordered to pay to each of the first, second, fourth, fifth, 12th, 13th, and 23rd claimant the sum cost in the sum of 500,000 naira. E, all other claimants woefully fail to establish entitlement to any of the reliefs due to failure to convince the court of their being in the employ of the dependent. F, all the monetary aspects of the judgment shall be fulfilled within 30 days, failing which the judgment shall attract 10% interest per annum. Judgment is entered accordingly.
That is why judgments have to be read to the open court. All witnesses, it's led by your lordship.
Yes.
Understanding of the labor matters before it's.
Yeah, okay.
Thank you, my Lord. But
You are
for giving
welcome.
us the opportunity to attend virtually.
You are welcome. Yes, call the next case.
My Lord, with your kind permission, we would log out now.
Yes, you are free to go.
Thank you, my
you are
Lord.
welcome.
See you soon, hopefully.
Okay.
Because we have to mention. We want to mention it before we call that case.
Okay.
Number NICNC 2022 between Mr. Gideon Wolabi and 1, the Commissioner of Police, 2, Inspector General of Police, 3, the Police Service Commission. My Lord, parties are all absent.
Okay. The administrator, we have come to the end of virtual meeting. You can end the meeting.